Hypocrisy.
Hey, what's up, guys? Welcome to Law-Splaining the Interwebs. I am your host, Nick Rekieta of Rekieta Law, a small law firm in central Minnesota. What's up, my friends, enemies, frenemies, whatever everything is? How are you guys doing today? I hope you're doing well. Oh, my goodness. Trying to get everything all set here. Yeah. Feel like I haven't streamed in years. It's kind of true. It always feels like that, no matter how long it is. You miss one show, it feels like forever. You miss 3, it feels like forever. I guess is how you say it. I don't know. What did I do to my mic settings? Are they wrong? Are they weird? Hold on. There we go. But yeah. Yes, Ben 31 UK. Thank you so much. Oh God, you know, without your concern for my health, I just would not know what to do. I've thought about it long and hard, and I'll take your advice. In just a second. I'm going to right now, I promise. Here we go. Oh, hold on. Here. Oh, jeez. God, I'm glad you told me to do this. Glad you told me to do this because it was necessary. Oh, cheers. There we go. There we go. Oh shit, I didn't lick the bottle. Fuck. I'm becoming a worse, better alcohol. Is that a better alcoholic or a worse one? God damn it. Okay, anyway. Oh my God. The internet is a magical place where everybody knows everything all the time. And I love it. That being said, look, we are back for part 2 of the Kiwifarms versus Russell Greer appeal. I actually have to get that document pulled back up because I have been having weird sound issues. I think my Rodecaster needs to be reset, but if I do that, I'm going to lose the mic for a minute. So I might do it at the break just to get my audio back, which is weird. But hold on. Let's go to history. Okay, I have to sift through all of the gay stuff. Where are we? Oh, God, that could have been anything. This one. Is this it? I think this is it. There it is. Okay, cool. Now I just have to get back to the page I was on. There we go. You're having trouble with consistency. I think that means alcoholism is when that's the bottle lick though, because I was definitely not having trouble with consistency with the show. Oh God. But before we get into this, we are going to we'll just talk a little bit about what's been going on. Over the weekend, I got to do my first stand-up show. It was supposed to be a Chrissy Meyer show, but she had a family emergency, had to jet out. But I was joined still by the wonderful Lila Hart. We were emceed by Aaron Imholt of the Steel Toe Morning Show. And we were also joined by a guy named Johnny, whose last name eludes me. I had not met him before, but it was a fun show. It was a blast. I hope the people who were there seemed to enjoy it. I don't know if that's actually true. What is this? I don't know if that's actually true, but I'm going to go with it anyway. The video of they did not video the whole show because I guess some people say offensive stuff at these comedy shows. And yeah, so Chrissy ghosted me. I don't think it was personal towards me, Broseph Josenbaum. No, Chrissy had a family emergency and had to bail on the entire show, which is actually really awful. She was out here. She was out here and had to leave abruptly either Friday. I think it was Friday or maybe it was Saturday morning. Timeline's blurry to me. But it is not my story to tell why. I'm sure it will at some point, everything will come out about it. I just want to assure people that Chrissy and the baby are in good health. There was some concern over that, but that is not the issue. It's an adequate issue. It's completely like no one who knows what happened is upset that she wasn't able to do the show. But again, it's not really my thing to tell. It's her family story. So I'll leave that in her capable hands. That being said, we had a great show. Still had a pretty kicking crowd. And the after party was great. Whatever the after party was, I guess we just went to another bar because the bar we were at, the venue was like a decent venue for the show, but the bar itself was horrifying. It was horrifying. So slow. Oh my God. People are just standing there for like 20 minutes at a time. What is this one? Go away. For like 20 minutes at a time waiting for drinks. It was terrible. But other than that, it was good fun. But yeah, we went to a different place afterwards, whoever wanted to go, I guess. And we hung out and it was a blast. So it was very cool. I had never met the Imholtz from the Steel Toe Morning Show. And so it was really cool to meet them. They're gracious hosts and they're like right by where I live. So it's kind of cool to have other people that like do some of this stuff nearby. And hopefully I'll be able to do some more one-off like stand-up things or whatever in the future. I don't think I'm going to make a lifelong career flying around the country doing stand-up like some people do. I don't know how they do it, by the way. I have no idea. It's a lot of travel. And it's a lot of work. Like stand-up is not the easiest thing in the world to do. It's a whole different medium. With this, you just kind of sit down and you have a topic to discuss and you go through the discussion. It's a lot more free form, free flowing. Stand-up, you tend to have jokes, and like the good stand-up comedians have jokes with a consistent theme and a story arc. It's almost like there's like writing involved and plots and all that. But it's something I'm not used to doing, but I had a lot of fun. So it was good times. Good times. I should lunge through the Chauvin updates. I mean, are there updates in the Chauvin case? Yeah. So the medical examiner's report said that George Floyd didn't die. The ME lied. George Floyd didn't die from Chauvin. He died from fentanyl, which was already, I think, a main point of the trial. I don't know. Unless that exculpatory evidence was withheld, I don't think they're going to get very far on that. But I'll have to look at what the actual appeals are in the updates. I mean, okay, I have to ask. This is the thing I love about the internet. I have to ask, guys, do you need me to say like Floyd died from fentanyl and not asphyxiation? Because that's not news. And I don't think you need me to convince you of that because you're telling me to look at it. Like I've talked through the way a guilty verdict happens in a murder trial where the direct cause of the death isn't necessarily the specific act, but it can be legally can be any contributing factor to a death. So even the fact that he's being kneeled on, crushed, right? The term that would be more energetically used. He's crushed under the weight of Derek Chauvin, the massive man. The fact that could have, in theory, led to a contributing factor in some sort of cardiac arrest or heart failure that was predominantly driven by the fentanyl. the logic behind it, whether you agree with it or not, is irrelevant here. The logic behind that train of thought is, if Chauvin had not been kneeling on him, would he have otherwise died? And we can say yes. But an absence of asphyxiation does not mean an absence of death automatically. And while it seems likely that he would have died anyway, a jury can conclude, because this is how we do things, that he wouldn't have otherwise died, and that even if the fentanyl was causing him to go into overdose, maybe, like because he was kneeling on him, they couldn't administer Narcan or something. Like, it's ridiculous level of theory crafting. Don't get me wrong, but it's permissible to have a contributing factor to the death be the factor, because you have to say that maybe in the absence of this, he would have lived. Is that fair? No, not really. Not really at all. And that's what a jury is supposed to suss out. So absent the thing, how do I word this? Absent an impossible conclusion by the jury, if the conclusion is feasible, it's going to stick. Like, I don't know what to tell you about that. Or I guess absent, again, the withholding of evidence, some sort of violation of the rules of evidence and the rules of disclosure, a Brady violation for exculpatory evidence, that's not going to result in an overturned conviction just because they're like, haha, because they made this argument. They're like, well, it doesn't say he's asphyxiated. And the jurors just disagreed, I guess. You never know, because they don't have to give their reasons. But again, that's saying without actually reading the appeal documents. If there are other points of appeal that are interesting, I'm happy to look into them and talk about that. But I don't want people to get excited about something that was already argued at trial, and now there's just more evidence corroborating it. Because if they had the opportunity to bring this evidence in, which they apparently at least brought some version of it in, then typically the appeals court is going to side with the jury trial. So it's lame. It might mean a man goes to prison for something he was not guilty of, and that's not a fun part of the system at all. I hate it, actually. So, but hey, they got the riots and stuff, got everything they wanted, I guess. As if it was ever about George Floyd, right? As if the Summer of Love was actually about George Floyd and not just about finding the appropriate opportunity to let a whole bunch of gaslit rage out into the streets and justify a bunch of bullshit behavior. So, So anyway, whatever. Also, Predator in the locals chat. If you want to hang out for the locals live stream, we could talk about it. Work through your feelings if we need to, my friend. Or you can DM me and issue all of your issues directly to me there. But I'm not going to be able to follow along with all of them as I'm doing the show. Like I try to watch the chats, but I'm not that great at it. So anyway, that being said, we've got that going on. Depending on how long this document takes, and it was taking a while the other day. So I'm not quite sure how far we'll get through, if we'll get through all of it in fast enough time. But I would like to talk about the Sidney Powell guilty plea. People seem to misunderstand the fact that people plead guilty to non-criminal acts and things all the time, like things that they didn't do or things that wouldn't actually be illegal. They plead guilty to them with relative frequency. So people are like, aha, she did conspiracy. She did conspiracize. And they don't also seem to understand that a person in an alleged conspiracy can plead guilty to the conspiracy while the other person can be found not guilty of a conspiracy. So it's it's kind of a weird subject, but look, I mean, Sidney Powell faced, I think, 7 felony charges and pled guilty to 6 misdemeanors with no jail time. Oh, she has to write an apology letter to the state of Georgia, though. That's gonna be rough. But of course, now there's some controversy because I guess Trump is now trying to claim that Sidney Powell was not actually a lawyer for Donald Trump, and Sidney Powell wasn't a lawyer for Donald Trump. She was brought on stage for a press conference, I think by Rudy Giuliani. And if anybody remembers that press conference, she's like gets up and she's talking about the Kraken. Everybody's looking at her like, the fuck is this? But there are ways to find out if someone is actually representing someone else. Like there's engagement letters, there are retention letters, or retention agreements. There's all sorts of records of representing someone specifically. And it's almost like you could prove that Sidney was actually one of Trump's lawyers if you wanted to. People are trying to pretend that Sidney Powell not being on Trump's legal team is a new position, but it's not. It's maintaining of a very old position. But I want to talk about that. People don't necessarily understand what it means to testify truthfully. And so I want to get through that as well. Someone said, Nick, how did you, why are people saying you knew Riley would visit the Isom grave? Well, I didn't know that Riley did visit the Isom grave because the guy who took the picture, Moronic Opinions on Twitter, is not Riley. So I wasn't aware that Riley did visit the Isom grave. Has he? I mean, it seems like something he would do, but I thought the whole funny thing for all of them was that he got cucked by the other guy going first. That was the joke on the tweet when Dick retweeted, Riley got scooped by him. So as far as in advance, no, I don't think so. I could have probably guessed, but I didn't even know that the grave thing was going to happen until after it had happened, because I don't actually listen to Dick's show or watch it, because I don't watch or listen to anybody's shows. I don't know how many times I have to say this, but I found out about it on Twitter with everybody else, and I was like, damn it. So there you go. But I don't know why people are saying that. I guess because I know Riley, that I would know that. I don't know. He didn't tell me. The reason why people are saying it is very simple. It's the internet, and people are retarded over and over and over and over again. They will always be. It is the one consistent aspect of the internet is people will be retarded. But yeah. So anyway, that's what I got on that one. Let's see. There's a super chat here that we'll get to, and then we will get going, I guess, into this thing. Oh, God damn it. I got to find out exactly where we left off on the last show. So give me a moment. I'm going to do this the very, very awesome way of going to the end of the last stream and seeing what page we were on. Where was that? Here we go. There it is. All right. No, go. Damn it. Go to this. Okay, here we go. Hold on. 1 second. Doing this in a very, very technical way. 15. Perfect. Thank God. All right. Gooino. All right. Page 15 is where we are. I've got it pulled up right here. Pull up. So I'll give a little refresher on where we are in this case as well. But first, we've got Idea Machine says, I wish we lived in an alternate timeline where Rackets is still Null's buddy and movies still have gratuitous nudity. Well, yeah. Me too. But that's not the way it goes, because some people, I guess, have feelings or whatever, and they don't like them being hurt. I don't know. People should get rid of those. With that, so a brief background, if you don't remember this case, or if you have not been paying attention, or if you've never heard of it, this is a guy named Russell Greer. I'm not going to go through the whole backstory. He sued Kiwifarms and Joshua Moon as the owner of Kiwifarms for something called contributory copyright infringement. The idea is that he has not only enabled, but encouraged someone to infringe on Russell Greer's copyright. I don't agree that he did that necessarily. That's the issue at court, and that's what Russell Greer is suing for, but that does not mean it happened. Personally, I have said, I think this lawsuit is very dangerous. I thought this lawsuit was over, and I didn't think his appeal really had any merit. The appeal was not on the merits of the case. If people don't know this, the case was dismissed via what's called a 12B6 motion to dismiss. It's failure to state a claim in federal court. It simply says that based on what was pled in the pleading, the complaint, that there is no legal remedy that the court can provide. So it needs to be dismissed out. It's dismissed with prejudice at that point. Russell Greer appealed that and says that his pleading was sufficient to move past early dismissal and then into the case. This does not decide anything about the merits of the case. It is completely neutral. Like, to get a temporary injunction, for example, you would have to prove that you have a likelihood of success on the merits of the case to warrant the injunction. In an appeal on a 12B6 motion to dismiss, they just review the record that is before them and determine if the complaint has sufficiently pled a factual basis to bring the allegations to the court. And if all of the facts are taken as true and uncontested, the case would be possible to be decided in their favor. It's a very low pleading standard, but a lot of cases do miss it. If you forget to provide some factual statement about some element of a civil issue, then you lose. Because if you don't have any fact statement about it, you can't bring evidence to prove the fact statement that doesn't exist. You have to allege that this factual thing occurred. You cannot merely say someone did a legal conclusion. For example, you cannot say someone defamed someone. That would be a legal conclusion. You could say someone said this. It was not true. It is not true, and they knew about it. Like, you lay out the factual basis for each element of defamation and say that, and then you can lead a court to conclude that defamation occurred. And then, of course, the quibble would be over those facts. That's how these motions work. That's how this case was initially decided. And now the appeals court has reversed and says, no, Russell Greer's pleading isn't great because he's a pro se litigant, but giving proper deference to a pro se litigant, he has pled a sufficient factual basis. Now, the idea, again, is contributory copyright infringement, which merely means that Josh and the Kiwifarms have set up an environment for which copyright infringement can occur and have encouraged or induced that behavior to occur, not merely allowed. It is not merely allowing behavior to occur for contributory copyright infringement. They have to actually participate in it by inducing or encouraging that to happen. I hope that is a sufficient summary, because I really don't want to belabor this. If you want a longer explanation of the case, watch the beginning of the last live stream in which we started covering this thing, and then you'll get the full picture. But for now, I think that's sufficient to where we are. So we're going to start right here on section B, section B on page 15. And I believe that is where we left off. Where are we here? Boom. And we will zoom in. So, for his, being Russell's, complaint to survive a motion to dismiss under contributory liability theory, he had to plausibly allege his copyrighted work was directly infringed by a third party. Mr. Moon and Kiwifarms knew of the infringement, and Mr. Moon and Kiwifarms caused or materially contributed to third parties' infringing activities. That's citing diversity. We address each in turn. 1, the district court correctly concluded Mr. Greer sufficiently alleged direct copyright infringement by a third party. And remember, for the purposes of these motions, every well-pled fact is taken as true. So it doesn't mean that it is true. It means that for consideration of the motion, the court is going to accept that it's true. It has nothing to do with what will ultimately occur. Mr. Greer's complaint alleged copyright violations related to his book and music. Mr. Greer provided the registration numbers and effective dates for both, providing registration number of this and the date of October 2017 for the book, then another registration and registration date of April 2019 for the song. He included certificates from the United States Registrar of Copyrights, and Mr. Moon and Kiwifarms do not dispute these copyrights were validly registered and their certificates appropriately issued pursuant to 17 USC 408 to 410. Now, footnote here says Mr. Moon and Kiwifarms appear to challenge only whether the complaint satisfies 3, the material contribution element. Right, because they know or they accept that he has a registered copyright. The registered copyright numbers are provided. Nothing there is a surprise. And they know that they know, quote unquote, that the infringement has occurred. He's at least sufficiently pled that part because he issued a DMCA takedown request. And Josh, I believe said that the DMCA takedown request itself was insufficient, not that the work was not infringed upon, that the copyright was not infringed upon. And this is maybe a tough point for Josh. Like that might be a downside to what his argument could have been. I'm not saying that he should have gone with this, okay? And it might be something that can be argued at trial. But for example, there's shields to fair use, or shields to copyright, fair use being one of them. But there's a whole bunch of ways that copyright can be, quote unquote, infringed and be justified. And I think there's sufficient argument out there that though the original link to a Google Drive allegedly contains an infringing copy of Russell Greer's work, the posts on Kiwifarms themselves are the content. And therefore, there is a question, in my opinion, of the sufficiency of a fair use defense. I don't know how else to say it, right? Like, they're not posting this thing to Kiwifarms or wherever to steal Russell Greer's book, like, because they want the book. That's not what's going on. The idea is that people have the ability and opportunity to mock said book, to criticize it, to make parody of it, to satirize it, whatever you want to do, to add all of the elements that would transform the purpose and nature of the work into something else. Now, it's a collective effort, I guess, by multiple people, and that might be a very strong argument against a fair use defense under traditional law. But, you know, Russ has this weird problem in this case, in that, sure, Russ has sued Josh Moon, but Russ has also sued Kiwifarms collectively, and Kiwifarms isn't a thing. But is it? Maybe it is. Because for whatever reason, this case is not dismissed as to Kiwifarms, which is a non-entity. It's a website that is owned by an entity that I think doesn't exist and owned by Joshua Moon. But if Kiwifarms is an entity, if we're going to go with this legal theory that Kiwifarms can be collectively responsible for contributory copyright infringement, shouldn't Kiwifarms as a collective entity be able to collectively assert a fair use defense of that copyright infringement? Maybe. I don't have a legal citation for it. But if we're going to go with abstract legal theories on how you can hold something that doesn't exist accountable for copyright infringement, maybe we can use those same abstract theories to collectively allow for a defense that would normally be available only to an individual. I don't know. Maybe that'll get flushed out. Maybe not. I wouldn't lead with it as an argument, but it's an interesting thought, right? Because the purpose of a forum is to crowdsource information, whatever that information is. Information, opinion, criticism. Kiwifarms is clearly a place that crowdsources a ton of criticism about any given subject. So how is that not a transformative use at that point? Again, people aren't going there because they're like, wow, I really wanted to buy this on Amazon, but instead, like they're shitting all over the book and Russell Greer, generally speaking, and the song. So, presumably, if someone were to upload a copy of the book with every fucking line annotated and criticized, that may be a sufficient fair use exception to copyright infringement. Well, if that's effectively done through the forum, then has that been done? And I don't know, because when the Copyright Act was written, they weren't really considering the viability and possibility of like social media crowdsourced criticism in the same way. Information just wasn't delivered in that way. And the Copyright Act has been updated since then, but has it been sufficiently updated to handle this thing? Is it properly done through the courts? Who knows? But again, we'll have to see how that ends up working out. This is a 12b6 motion to dismiss. They're not really getting into the other stuff there, and 12b6 is different than asserting your defenses. So in an answer or whatever, we'd get more information about how they would actually defend all of the allegations. And they may actually go after some sort of affirmative defense like fair use or educational purposes or newsworthiness, things like that. Again, each of those will have mileage may vary on each of those things. But in a case like this, you'd want to go with every possible option. And especially if, as Josh seems to assert, and I tend to believe, he's interested in actually preserving the purity of the internet and the ability to have discourse and freedom of speech. Because let's be honest about this. Russ is not suing Josh and Kiwifarms for copyright infringement. He's not. I mean, he's using that as his excuse to sue Kiwifarms. But Russ is suing Kiwifarms for hurt feelings. At the end of the day, that's all it is. His feelings are hurt. He wants to stifle the speech of the speakers on Kiwifarms. He wants to stifle Josh because they make fun of him. I don't know how else to say it. So this is a proxy lawsuit in that respect. But if you bring a valid claim, it doesn't really matter the underlying motivations. They'll still have to go through the process of determining if this thing occurred. But it's a copyright case, but it is really also a case about speech because that's what's attempting to be punished here. Okay, so back to this. Recall the Copyright Act grants copyright holders like Mr. Greer the generally exclusive rights to reproduce the copyrighted work in copies and to distribute copies of the copyrighted work to the public. Usually when a third party reproduces or distributes a copyrighted work without authorization, they infringe on the exclusive rights of a copyright holder under 17 U.S.C. 501. This is true. Usually they do. Now there are, again, affirmative defenses like fair use. In his complaint, Mr. Greer alleged he discovered the book had been illegally put onto Kiwifarms. Now, this is a legal conclusion. This is one of those conclusory statements I was talking about earlier. Saying something is done illegally in your complaint does not mean it was done illegally, and that statement would typically be disregarded. Now, they may give him some deference on this because he is a pro se litigant. They may also just simply say, I mean, yeah, that's a conclusory statement, but he has other sufficiently alleged facts. In January of 2018, somebody, he explained, created a copy of his book and put it in a Google Drive that is accessible on Kiwifarms. Cool. The complaint also included allegations other users on Kiwifarms have created unauthorized audio recordings of the book and have put them on various sites. Okay, I guess. Kiwifarms, Mr. Greer continued, quote, has links to these audio recordings. As to the song, Mr. Greer alleged he found an MP3 of his song was on Kiwifarms in April of 2019. Now, I don't know why they have links to his songs to like MP3s of it. It's on SoundCloud. I think it's on Spotify and stuff like that. A Kiwifarms user posted the song with the comment, "Enjoy this repetitive turd." Another user commented, "Upload it here so no one accidentally gives Mr. Greer money." I mean, I guess this is why. And that's petty. Just give him his like 1 cent per 1,000 plays. Leave him alone. The complaint also alleged Mr. Moon's users spread Greer's songs across different sites. Based on the complaint, we conclude, like the district court, Mr. Greer plausibly alleged direct third-party infringement of copyright under 17 U.S.C. 501. Now, they're being very belabored about this because of how appeals on 12b6 motions work. This is an appeal that is done what's called de novo, which means they take a look at the record itself and what's before the court, and they look at what the district court decided, but they ignore what the district court decided for the purposes of their decision. They accept what's in the record that the district court has allowed in or not allowed in if there were objections and exclusions of evidence. And then they say, okay, we'll take these in-field calls by the court, but we're going to ignore the court's analysis and just do our own, because they get to do that. There's nothing that they need to have balls or strikes called on. They're not taking new evidence in. They're not asking witnesses. They're simply analyzing, does this thing survive under a quote unquote proper legal analysis done by a very much smarter appeals court? Overemphasizing, but that's the idea. But that's why they're going to go through each of these points in a very specific and fully fleshed out way rather than just briefly doing it. So on appeal, Mr. Moon and Kiwifarms suggest the copyright infringement here may have been, quote, for purposes such as criticism and or comment. Oh, there we go. So there's kind of a fair use and is thus protected under the fair use limitation of 17 U.S.C. 107. Applebee's brief at 33. The paragraph discussion identifies the 4 factors in 17 U.S.C. 107, but fails to explain what those factors are or why they apply here. Ouch. We do not address this passing mention of a novel issue. See Day versus SkyWest Airlines, declining to consider a newly raised, inadequately briefed, and analytically complex issue on the first instance on appeal. So this was apparently a complete failure of briefing fair use, which I just spent a whole bunch of time explaining that might be a potential way to go after this, because I didn't remember what was actually discussed in their pleadings. So there you go. I guess maybe they should have laid out why the 4 factors would apply. Man, that's rough. In any case, Mr. Moon and Kiwifarms did not plead the affirmative defense of fair use, and as a general rule, a defendant waives an affirmative defense by failing to plead it. Well, fuck. I guess that's going to make it harder. Okay. Citing Berg versus Relgado, which is citing Bentley versus Cleveland City, or Cleveland County Board of County Commissioners. See also Federal Rule of Civil Procedure 8C, explaining a party must affirmatively state any avoidance or affirmative defense. All right. Okay. Perhaps to get around the bar of waiver, Mr. Moon and Kiwifarms described fair use as more than an affirmative defense. The language of the statute makes it clear that fair use is not infringement at all, which is a decent argument. But we decline the invitation to transfigure fair use into an unwaivable defense. Fuck. See Andy Warhol Foundation for the Visual Arts, Inc. versus Goldsmith, explaining fair use is an affirmative defense, and the party invoking it bears the burden to justify its taking of the protected work. That's Gorsuch's concurring opinion discussing a party's invocation of the affirmative defense of fair use to claim to a claim of copyright infringement. So I guess, I guess Scortis fucked that up. The district court also concluded Mr. Greer sufficiently alleged the defendants knew of the direct infringement. Here too, we agree. Mr. Greer's takedown notice complied with 17 U.S.C. 512C3, takedown notice under the DMCA needs to identify the copyrighted work claimed to have been infringed, material that is claimed to be infringing or to be the subject of infringing activity. Here, Mr. Greer's original email and DMCA notices identified the book and song protected by copyright, pointed to the locations on Kiwifarms where these works were being copied and shared without authorization, requested Mr. Moon, as site administrator, remove the infringing material. While Mr. Moon debated the merits and style of Mr. Greer's takedown notices, claiming in emails the infringements were protected under fair use and mocking the use of a template for the DMCA request, the complaint sufficiently alleged that Mr. Moon knew of the alleged direct infringement. So again, Josh is now being, I guess, admonished by the court for asserting that the DCMCA notices were insufficient, while they clearly decided that they are sufficient. So there you go. There you go. Woo. For contributory liability to attach, the final diversity prong requires the defendant to cause or materially contribute to third parties' direct infringement. The Supreme Court has described contributory infringers as those who are, quote, in a position to control the use of copyrighted works by others and who authorize the use without permission from the copyright owner. As applied here, Mr. Greer was required to plausibly allege Mr. Moon and Kiwifarms caused, materially contributed to, or authorized the direct infringement by Kiwifarms users and other third parties in Mr. Greer's book and song. We conclude he did so. Now, again, they conclude for the purposes of the motion to dismiss based solely on the alleged facts. They have not gone through a proper evidentiary examination after discovery, the calling of witnesses, a full trial, all of that stuff. A fact finder has not been involved here. This is just taking the pled facts as true. The district court correctly explained the diversity factors and rightly identified the liberal pro se pleading standards. Nevertheless, it dismissed Mr. Greer's contributory infringement claim after concluding what is missing is the defendant's intentionally causing, inducing, or materially contributing to the infringement. It is not enough, the district court continued, for a defendant to have merely permitted the infringing material to remain on the website without having induced or encouraged the initial infringement. Now, here we go. This is going to be maybe where they fucked up. The district court referenced an initial infringement, but we remain unsure what the district court meant by the addition of the qualifying initial. Mr. Moon and Kiwifarms claimed the district court meant Mr. Moon needed to have taken steps to encourage the initial infringement by Kiwifarms users. We cannot understand initial to be a literal requirement supported by applicable law. Otherwise, contributory infringement liability would rarely, if ever, lie for ongoing repeated infringements. So here they're disagreeing with the district court on this use of initial, which is a pretty important thing. Did Joshua Moon induce or encourage people to post the infringing material in the first place? No, I don't think so. Did he permit it? Sure. But I mean, permitting something to be posted on a forum is not like a thing that you like. It just, people post it. It's permitted if it's not somehow a prior restraint that needs approval. So he permitted it. Did he induce or encourage it? I don't think so. I don't see any evidence of that stuff. But after being notified, after receiving the DMCA and refusing to take it down, now did Joshua Moon induce or encourage the infringement that was ongoing? And I think a really good part of Russ's argument here, though I still don't really want this to be the winning part of the case, but a good part of Russell's argument is by not only rejecting to do the DMCA takedown, but also by mocking it, by posting it, making fun of Russell Greer, and having a thread that follows in which possibly more infringement would occur or brought more attention to the infringement. Now he may have induced or encouraged it. Again, if you get rid of that word initial, it changes the whole calculation. So here we go. On appeal, Mr. Greer contends he sufficiently pleaded factual allegations of inducement and encouragement. Mr. Moon and Kiwifarms replied they simply allowed an infringing use to exist on their website, and so cannot be liable for the actions of their users, even if they knew about the alleged infringement. So here we go. The parties debate the meaning and applicability of the Ninth Circuit's test for contributory infringement as expressed in Perfect 10 Inc. versus Amazon and A&M Records versus Napster. Mr. Greer argues the district court erred in refusing to follow persuasive authority from a sister circuit and expressly urges this court to adopt the Perfect 10 Napster test. Because we conclude the issue is resolved under controlling precedent in this circuit, including Grokster and Diversey, we express no view of the Ninth Circuit's contributory infringement framework. So they ignored that Russ asked for that because they say we already have it. So here we go. We discern no error in the district court's explanation that contributory liability requires more than merely permitting the infringing material to remain on the website. And we conclude Kiwifarms and Mr. Moon accurately state the law when they argue a website owner or operator must do something other than allow an infringing use to exist on their website. But these general principles of law are of little help here, where the record shows, and Mr. Greer's complaint plausibly alleged, far more than, quote, a failure to take affirmative steps to prevent infringement. It's Grokster. When Mr. Greer discovered the book had been copied and placed in a Google Drive on Kiwifarms, he sent Mr. Moon requests to have his book removed. Mr. Moon pointedly refused these requests. In fact, instead of honoring the request, Mr. Moon posted his email exchange with Mr. Greer to Kiwifarms, belittling Mr. Greer's attempt to protect his copyrighted material without resort to litigation. So I guess we're to conclude that Joshua Moon should not have dared Russ to sue him? Because if you dare someone to sue you, say they will have to sue you over it, then you deserve to lose, I think, right? Or be punished by the court. And that's what the court is saying here, is that Josh mocked Russell Greer because he believed he was on solid legal footing, and he dared him to sue him. And then Russ did. So they're saying that that is some sort of affirmative step. After the email request, Kiwifarms users continued to upload audio recordings of Mr. Greer's book, followed by digital copies of his song. When Mr. Greer discovered the song on Kiwifarms, he sent Mr. Moon a takedown notice under the DMCA. He not only refused to follow DMCA's process for removal and protection of infringing copies, he published the DMCA request onto Kiwifarms, along with Mr. Greer's private contact information, which shouldn't matter at all, in all honesty. Mr. Moon then emailed Greer and derided him for using a template for his DMCA request and confirmed he would not be removing Greer's copyrighted materials. Following Mr. Moon's mocking refusal to remove Mr. Greer's book and his song, Kiwifarms users have continued to exploit Greer's copyrighted material, including 2 additional songs and a screenplay. Oh, a screenplay, Russ? Really? Oh. Wow. Construing the pro se complaint liberally and drawing all reasonable inferences in Mr. Greer's favor, we find Mr. Moon's alleged conduct to fit within our understanding of material contribution. That's got a footnote. Because we find Mr. Greer's complaint plausibly alleged contributory infringement, we do not reach the district court's denial of Mr. Greer's motion for leave to amend. Nor do we express an opinion about Mr. Greer's appellate contention that the original complaint pleaded sufficient factual allegations to make out a showing of direct copyright infringement and likely vicarious copyright infringement as well. So here we go. Mr. Greer sent repeated requests to Mr. Moon identifying the materials on which he held the copyright, as well as where and how his rights were being infringed. Mr. Moon not only expressly refused to remove the materials, he mockingly posted the correspondence to Kiwifarms. Under the circumstances, this is not the passive behavior of one merely permitting infringing material to remain on his site. Rather, we conclude a reasonable inference from the facts alleged is that the reposting of the takedown notice, combined with the refusal to take down the infringing material, amounted to encouragement of Kiwifarms users' direct copyright infringement. Mr. Greer's complaint alleged Mr. Moon knew Kiwifarms was an audience that had been infringing Mr. Greer's copyrights and would happily continue to do so. I don't think that's relevant, honestly. Indeed, Kiwifarms users have been uploading Mr. Greer's copyrighted materials with the explicit goal of avoiding anyone accidentally giving Mr. Greer money. Oof. Further infringement. Again, you could have just posted the links to his SoundCloud. Further infringement followed, encouraged, and materially contributed to by Mr. Moon. We old Mr. Greer has stated plausible claims of contributory copyright infringement against Mr. Moon and Kiwifarms. The judgment of the district court is reversed, and this case is remanded for further proceedings. Well, there we go. That's that. So what does this mean? What does Mr. Greer's victory at the appellate court mean? Does it mean he wins? No, not at all. Does it mean that this case proceeds into discovery and then potentially to a trial? Yeah. Does it mean it goes to trial? No, not necessarily. There's still other pretrial remedies. There could be a settlement. There could be summary judgment. Summary judgment would basically be to accept that there are no factual disputes on the record that need to be resolved, and that the judge could then render a judgment without a jury trial because there's no finder of fact that is necessary. A trial before a judge, a bench trial before a judge, or a jury trial before a jury puts one of those two entities as a finder of fact. A judge is a finder of fact in a bench trial. Jury is a finder of fact in a jury trial. Not to belabor that point, but that's what it is. And so their job is not actually to decide the law. Their job is to decide what facts are correct, and then you plug it into the formula. Because you have an argument over what facts occurred, not whether a law was broken. Typically, those legal arguments are done at the dismissal phase and stuff like that. Trial arguments, court proceedings, are over what facts are true. One fact is more likely to be true than another fact. The more true fact wins out. And then once you have discerned a factual record, you plug it into the elements of the case or elements of the underlying law, and it's a math formula at that point, theoretically. That's the idea. Is that true? No. Practically no, but that's the concept. But if they don't need anyone to resolve a factual dispute, then you don't need witnesses. You don't need testimony. You don't need evidence to be brought in. You have the facts. If everybody agrees what the facts are and just says, decided on the law, judge, the judge will render a ruling on the law. That's his job. So it's now going to proceed on. And where that goes, the one sure thing about where it goes is into money. Is now expensive. It may have already been expensive. It is now significantly more expensive. Now parties will have to comply with whatever discovery requests. What are those discovery requests? Will Josh be forced to turn over IP addresses of people who posted allegedly infringing content? Maybe. Will Josh be asked to produce communications between him and users of the forum about allegedly infringing content? Maybe. Could all of Joshua's communications be brought forward in a discovery effort? Probably not. That would be overbroad. But limited to the materials of any discussions he has had with people about Russell Greer? Sure. Really is going to depend on what Josh has preserved over the years in regards to the forum. Like, what data does he have? What communications logs does he have? What do the servers maintain? Maybe Josh has some nice shields to discovery in the fact that Kiwifarms has been taken down over and over and been the subject of multiple attacks. Maybe he has a justified reason for not having various types of electronic data. To be clear, I don't know what he has and doesn't have. I have no idea. I don't even know how to define the things that he might have or not have. I do not do this stuff. That is not my field of expertise. I do not run websites. I do not own servers. I don't have any of that shit. So that'll be up to Russell Greer's lawyers to ask for and Josh's lawyers to fight over. And that is the shit about lawsuits that get really, really expensive and tedious and tiring and really burdensome. But that's the ropes. Now that it has made it through this initial step, discovery will be laid out. And your options are really settle out of court or proceed through. So, the real problem with something like a web forum is the absolute fucking massive amount of information that can be contained, right? Because, and again, I don't know how the website is managed, but hypothetically, there could be, how do I word this? Snapshots, right? On the website, like Internet Archive, right? You can have 7 versions of the same web page that have been taken at various places when people ask to archive it. Depending on what the servers retain for, I don't know, backup purposes and stuff like that, there could be multiple instances. For example, some posts could be deleted, some posts not deleted. This does not mean everything gets to be produced, and that's very important. Discovery requests have to be relevant to the actual issue at hand. Again, Russell Greer cannot go asking for DMs of all the nudes that Josh has received from men who love him. They can't do that. Thank God, because all of mine would then be subject to display. And we don't want that. Nobody wants that on the internet. But that being said, that just wouldn't be relevant to the copyright infringement. Now, could Russ ask for any communications involving Russell Greer from Josh? Maybe. And that could be any communications that he has, text messages, emails, whatever, any messaging system through the forum, posts that he has made or other people have made, including deleted posts if they happen to have archives of them. That type of stuff. This is what makes it burdensome, is going through all of this shit and then producing it. It's expensive. You typically have to hire specialized firms to do that because otherwise you're trying to do it on your own, and most people don't have time to go through and do all that shit. They're e-discovery firms that do this exclusively. And so that's why these things become such a pain in the ass, and everything gets bogged down and everything takes forever. Also, this is federal court. This could be going on for a year, 2 years, 3 years, who knows? It could take forever. And the worst part about all that is that now, as this case is going on, Josh will have a duty to preserve any potential evidence, which means that anything that is missing, that goes missing later, whatever, any loss of data or servers will have to be plausibly explained, or he could face sanctions from the court for not complying with discovery. That could be a mess. Now, similarly, Josh can try to, squeeze out of Russ any sort of information about authorizations he may have given to people to reproduce content, things like that. Maybe Russ created the Google Drive and Russ was the initial infringer. I'm not saying that that's true, but if you hate someone, I don't know that Russ hated Josh before this, so bear with me. But if you hate someone and you could set up a situation where you create an anonymous Google Drive and upload it to a website and then DMCA request it, in theory, I guess that could be a thing. Seems very out there, but Russ is a very out there guy. So Josh would be able to try and find any information he could to levy up some sort of defense as to what happened, or to, I guess, shift some blame back onto Russell Greer. All of this stuff is what discovery is for. What actually has occurred? It could be a mountain of data. It could be not very much. The other issue is that, well, any live streams, any videos, anything like that Josh has produced on any websites that involve Russell Greer or his DMCA infringements, those could be requested in their entirety, even if they've been taken down. If he happens to have archives of them, those things would be able to be gone through. And that shit gets expensive too, because you often have to pay to have them transcribed and all that stuff. So it's a mess. Arclight says Nick alleges Russell posted his own stuff. Russell must now hand over all of his personal communications. Not quite. I didn't allege it. I said Josh could request anything that might lead to that conclusion. For example, a list of email addresses that he's used, things like that, to try and identify him as the owner of the Google Drive. Would he produce it? Probably not. Would you be able to maybe find it? I don't know, right? Like, that'd be the idea. To be clear, I don't think that that is a reasonable thing that someone would do, but it's the internet. People are often unreasonable. So throwing darts at what you kind of guess for here with Russ's communication. We don't want is any audio communication from Russell Greer, because that would be a fucking nightmare to try and figure out what he's saying. Just terrible. Just terrible. You know, he could also potentially find, either of them could potentially find embarrassing stuff about the other incidentally in these requests, as long as they could plausibly relate it to the case at hand. So, you know, he could request, and I guess, information on how Josh has dealt with other DMCA requests. Maybe he didn't post them all. Maybe he honored some. Maybe he didn't honor others. I don't know. Like, those are things you would want to find out. Was Russell treated differently? Was this particular instance of copyright infringement encouraged? The fallout from that could be nothing, or it could be annoying, right? What if someone else finds out that their contributory copyright infringement claim might be valid? There's a domino effect that is possible in cases like this, especially with data that comes out, especially if there's communications related to how Josh deals with DMCAs. I don't know who he would talk to at all. To my understanding, he's the only site administrator of Kiwifarms who'd be the sole decider of this. But, you know, there you go. So there's a bunch of shit that can come as the fallout of this. And that's really annoying and burdensome. That's why no one wants to go through it, because it's bullshit. And I do still think that this is, like, I get the court's analysis here. Their analysis that Josh contributed because he made fun of Russell Greer. I don't know that I fully agree. But if he did fully waive his ability to use fair use as an affirmative defense, that's going to be fucking rough. That's going to be rough, because now you've eliminated an automatic win in saying, well, it wasn't infringing in the first place. None of it is. It's all criticism of him. And it's all valid criticism because of the 4 pillars or whatever. But if he waived it, and I'm not sure that they'll get to rebrief that issue. Someone mentioned that, well, in 12B6 motion, you don't argue copyright infringement, but there is a waiver of affirmative defenses based on the order that things are done. I'm not fully familiar with the procedural order, and I haven't had to deal with federal rules of civil procedure in terms of waiver of affirmative defenses since law school. So I don't particularly remember. It would be a thing I would have to research. What people may not know is civil procedure is its own specialized field of law. And when you have complex procedural issues, or even if you don't have complex procedural issues, you may have lawyers whose field of practice is simply civil procedure to make sure all of this is done, and then can be argued on appeal if it is done incorrectly. That is an entire practice area of law that has nothing to do with litigating underlying issues. And you may have, depending on the firm, you may have a civil procedure lawyer, or you may go to an outside lawyer for complex civil procedure issues. And they might have a complex civil procedure issue here with the order of those affirmative defenses. So being able to get fair use back in play might be crucial. But the appeals court just kind of said, sorry, bend over and take it. And that's not a great place to be. But we shall see. Research it? No. No, for now, I don't need to research it. For now, the appeals court has done it for us. They have said, you have waived your affirmative defense of fair use because you said it wasn't an affirmative defense, and you didn't brief it, and you didn't plead it, and you're wrong. There. That's the research that needs to be done. If they want to bring that issue back up later, that will be, you know, up for them to try and bring it back in. There's no purpose in researching it outside that, unless if they try and raise that in some motion before the court going forward. Sure, we'll look into the arguments, but other than that, there's no reason to research it. The appeals court has ruled, and unless you're going to try and appeal that to the Supreme Court, which they will not take on that issue, almost guaranteed, then you're kind of fucked. Brian Ogden says it's a great fair use debate. I agree, but they may have completely forfeited their ability to have that debate before the court. And you can always take that up with the Court of Appeals, but you just heard what they said about it. So you're barking up a really shitty tree there. All right. With that, there's not much else to talk about on this thing. Look, the issue is, what are you responsible for as someone who owns a website? Lots of people own websites. Not everybody owns a Kiwifarms, but lots of people own websites. For that matter, how much control do you have over things like Facebook accounts, Instagram accounts? Now, could someone send a DMCA to you over what's on your Facebook? Like, that'd be weird, right? But you have control over what's posted on your Facebook. You can block people. You can take down shit that's a reply to your stuff. You have the ability to control it. Can you find some weird contributory copyright infringement liability there? Maybe. What are the implications of these types of decisions? That's the scary thing. But ignore stuff like Facebook and social media, because people have websites with comment sections all over the place. I mean, it's just a WordPress, right? WordPress has been around. Kiwifarms is not just a WordPress, but a WordPress blog has comment sections and you have full control over them. Like, they could DMCA to WordPress, but if you're like a pro user, people don't even know it's WordPress necessarily. Or do people use WordPress? The idea of owning an independent thing is not weird anymore. Tons of businesses have it. Tons of businesses have the ability to post on something akin to a forum, and they therefore have something akin to responsibility of what's posted over there, depending on how the courts rule on this stuff. And that's kind of fucking scary. Jim Satala says, can you explain why it's not Google's issue? They're hosting the infringing content, not Kiwifarms. Wouldn't he have had to send a DMCA to Google? It's on a Google Drive account. That's a Google server. No, it might also be Google's issue. That's a separate question. The question is not, did Google also contribute to the infringement on Russell Greer's material? He'd have to sue Google, or he'd have to DMCA Google. And Russ is under no obligation to DMCA any particular person. This is one of the key differences between copyright and trademark, is that in copyright, you have no affirmative duty to enforce your copyright. None. You can choose to never enforce it except for that one motherfucker who you don't like. You could give 7.7 billion free licenses to your work and then not one, because you don't want George Soros to post it or whatever. Like, I don't know who it would be, but that's what you get. You don't have to, you do not have to enforce your copyright. Trademark, if you refuse to enforce your trademark enough, it will be invalidated. They'll say, you don't actually care about it. Too bad. So sad. There's a process to it, but yeah, that's a defense to trademark infringement as well. Everybody infringes on it. But with copyright, not the same thing. You have exclusive, unlimited control for the duration of your copyright. So with that, would Google potentially be responsible? Maybe. We don't know if Russ DMCA'd them. We have no idea. There's another possibility here. Now, I mentioned that the DMCA, or that the Google Drive was potentially like Russell Greer, like the conspiracy theory of it. Well, what if it was Russell Greer, but he did not authorize the sharing of the Google Drive? Maybe Russell Greer shared the Google Drive with a company to print the work, right? Simple. Like, can you print this or turn it into ebook format or whatever? And someone at the company took that link to the Google Drive, uploads it to Kiwifarms. Maybe Russ sent that Google Drive link out to 15, 20 people to review, to edit, whatever. Any one of them gets mad. Bam. They post it on Kiwifarms. Russ doesn't necessarily know who does it. Maybe it's his Google Drive. Maybe it's a Google Drive. He authorized them to use the Google Drive. Maybe he sent it to an agent. Who knows? We don't know who owns the Google Drive. We don't know what Russ has authorized, not authorized in reference to it. But there is a plausible way in which it is validly uploaded to a Google Drive, and that Google Drive is, without permission, linked, right? Like that's a possibility too. So, but could Russ DMCA Google over this thing? Probably. Did he try? I have no idea. Is it relevant? No, not for Kiwifarms' liability, only for Google's. But Kiwifarms is not responsible for the direct infringement, it seems. The direct infringement is not like Josh didn't directly infringe his copyright. There's no allegation that Josh has uploaded it. And I think that they got busted down on that issue. But maybe the whole complaint survives. So we'll see. We'll see what happens with it. But yeah, the long and short is it's not relevant. Google's liability is a completely separate issue to the case. So with that, let's hit the rest of the super chats. We'll flip over to Rumble, and then we'll probably go to some other issues. We'll talk about Sidney Powell. I didn't think it was going to be this fast. We'll talk about Sidney Powell a little bit. We can talk about some other stuff that's been going on. There's a little bit of, I feel like there's a little bit of stuff to, oh yes, I know people are very frustrated about the Eric July stuff on both sides of the issue, whatever, it doesn't matter. There's a legal theory out about the ISOM trademark, a legal theory, a conspiracy theory out there. And I want to actually pour some cold water on that slow burning fire, because I don't think it's actually a real thing. I think people are misreading something in the ISOM trademark lawsuit and looking deeper into it than possible. So I want to tamp that down a little bit. I talked about it briefly on Twitter, but we'll do it here. This is not on the side of the ministry. This is not on the side of evil Dick Masterson. This is entirely on the side of Eric July in this issue. So I want to make sure I'm covering the legal issue as fairly as possible. And when something that gets kind of picked up due to what is a perceived misunderstanding of legal procedure, I want to go ahead and try and shut that down so it doesn't spread out, because it's stupid. It's a stupid theory based on the information that is provided. I mean, is it a possibility in other words? Yes, of course. But there's no information to lead us to believe that is a thing. And we may also talk a little bit about Dick Masterson's appearance on Review Tech USA, which is actually a pretty entertaining interview, except for the fact that Rich is really fat and shirtless. I'll probably briefly talk about it tonight, but it may merit its own like e-fapping, because it's funny and there's some funny issues there, but I don't think I'm going to go through it tonight, because it was like at least an hour, I think, long. Lamau, did he take off his shirt? Yeah, gross. So we will hit the super chats. We will pop over to Rumble, and then we will move through the next topics, and we'll go there. Guntley says, could you law explain the implications of P starring on Graves, then bragging about it on Twitter? Need a non-practicing attorney's opinion. Hashtag YWNBAPL. You will not black at people live. I don't know what that means. Do you mean, what is P with 2 stars? Wouldn't it be 3 stars, like pissing or pooping? I'm not sure. Peeing? Maybe it's peeing. I forgot about peeing. The implications of peeing on graves and bragging about it on Twitter. Wait, who bragged about peeing on a grave on Twitter? I'm not aware of anybody even suggesting that they peed on a grave. I don't know that there would be a specific statute covering peeing on a grave. Maybe it would be desecration of a gravestone, but I think desecration of a gravestone typically involves, we could look that up. We'll look it up on I guess we'll look it up on Rumble. We know it's in Alabama. No, Arkansas. It's in Arkansas, right? So it's in the graves in Arkansas. So we look up the desecration of a corpse statute. I don't recall bodily fluids on a grave being included in desecration, but we can check there. People really misunderstand like stalking, harassment, and all of these little things that keep getting thrown around, because they're like doing this complex thing. They make out like it's doing this act of searching for and finding something and going to it amounts to stalking because I wouldn't do it. That's not stalking. Stalking typically involves a very involved process. And this is applicable to the sniper wolf situation and everything else. And it's really, really fact specific. But one thing to remember with all crime, damn near fucking every crime that exists, is there is an intent requirement. You don't necessarily have to intend to do something illegal, but you have to intend to do the thing that is illegal, if that makes sense, right? Like, this is a great example. If I intend to possess a bag full of cocaine, and so I go to someone and I buy a bag full of cocaine, and they give me baking soda, and I'm like, yeah, cocaine, baby. And I'm walking down the street, waving my bag, like powder flying everywhere, and a cop arrests me. He's like, what's this? I'm like, cocaine, bitch. I just bought it from a drug dealer. And then they test it, and they're like, baking soda. You still intended to possess the illegal thing. You thought, but were mistaken about what you possessed. But you had the intent to do the illegal act. That's like the criminal aspect of it. It's weird how it works. But if you intend to possess baking soda, in the opposite, you intend to possess baking soda, and you go to the store and you buy baking soda, but they happen to get the wrong truck. They got the cartel truck of baking soda, and like that's on the fucking shelves, and you buy it and you're like, make a cake and you're like, whoa, this cake is awesome, right? Like you do that. And then they're like, that's not baking soda, homie. Like the cake was flat, but it was really good. Like you've possessed the thing, but you had no intention to do. Like you're not a criminal. You legitimately didn't mean to have the thing. Now, good fucking luck arguing these points, right? Like good luck arguing that out. But that's the academic law around it, is you have to have the mens rea, the criminal mindset, the intention to do the thing. Now, the intention, where the intention ends, depends sometimes on the level of crime, right? If I intend to kill someone, I shoot him in the head. Well, that's first degree murder. I intend to cause the death of you, and I shoot you in the head and you die. There you go. If I intend to shoot in a direction and I don't know someone's over there because there's like, I don't know, a tree or a tarp or something, I can't see them. It's like, bam. Well, now you don't have first degree murder because you didn't intend to kill the person. You just intended to shoot in a direction. And now someone has taken a bullet in the head and died. Now you have a manslaughter or reckless homicide type charge because you've done something that was intentional. It's a criminal act because someone is injured. Your intention wasn't to cause the injury. But you always have to have that criminal intent. We do not criminalize accidents. We do not criminalize behavior that occurs that results in injury. That's what the civil system is for. So with the whole like stalking thing, the intent is not, I looked up something and went there, because I don't know if you guys know this, but looking up an address, residential, business, commercial, industrial, otherwise, and going to the address is not inherently unlawful or wrong. In fact, you probably do it all the fucking time. And I know some of it's businesses, but guess what? Some people work there. Or I know it might be like, maybe it's an apartment complex. Well, some people live there. Like you do this constantly. It's innocuous behavior. The intention behind it, what is the intent? Is it the intention for stalking tends to be a pattern of behavior that is intended to reasonably cause fear or apprehension in the victim. You have to understand what is happening in these types of crimes. So we'll talk about that a little bit more in specific with the pissing on graves or peeing on graves. And bragging about it on Twitter, but I'm not aware of anybody doing that. I know there's a theory that some retard came up with because they saw two videos or two different photos of the grave, and one had what appeared to be some moisture on it, and said retard was like, that means he pissed on. Okay, I guess that's the idea, but that's not like a real thing. That's a retarded person being retarded for the purposes of being retarded. Grifty says, wife had positive pregnancy test. Number 4 for me, number 1 for her. Toast. Does she know about the other 3, Grifty? All right. Grifty, congratulations, man. Kid number 4, new lady, kid number 1. Cheers to you, and a special wish of health, healthy development, healthy delivery for the baby, for the mom, and for your sanity. Cheers, brother. 3 is tough. 4 is actually kind of fun because you're already defeated. Good luck. Lord of the Kino says $2 for the Bourbon for Breakfast Fund. I actually had bourbon for breakfast the other day. It was great. I don't normally, but I was at a friend's house and they're like, do you want a Basil Hayden neat? And I was like, you know what? I do. That sounds terrific. Simon Ardeline says, hey, you need to read and mock the lawsuit against the gun companies for posting memes. It's ridiculous. I just heard about this today. Definitely want to look into it. Maybe you could bring Benjamin Blatt or Fudbusters or both on. We could all laugh at memes. Or Phoenix Ammunition, who has a very, very funny wild like campaign finance allegation. It's good. Nope. Hell nope says, I asked for everybody's thoughts and prayers while I fought the dragon known as the justice system. They were answered grand jury in a surprise twist. You know why? Came back with no true bill. Awesome. Great to hear, brother. The reason it's a surprise is because the meme about the grand jury system is that you can indict a ham sandwich because you have all of the advantages as the prosecuting attorney. Bad Dragonite says, what's a word that sounds like a slur but isn't? Let's see. What is a word that sounds like a slur but isn't? Rigor, I guess. Dumbass says, are you saying any plaintiff can be entitled to logs of business communications? Or are you wildly speculating under the guise of legal analysis? Yes. Do you think that business communications have some sort of insulation from discovery because they're business communications? Is that a thing? Guys, I never know how to take things because I get, especially when I'm covering something like Kiwifarms, you get people who like genuinely don't know the answer. And then you get people who like are trolling. And I have there's no way to tell. Yeah, dude, any plaintiff who plausibly pleads factual allegations sufficient to carry any case into discovery are entitled to any information possessed by the defendant or reasonably accessible to the defendant that is pertinent and relevant to the underlying issue. Yes. Yeah, it's wild. I don't know if that's shocking or not, but yes, of course. you get that. That's the whole purpose of discovery. If you could just shield everything under, well, it's a business communication, then you could just protect literally anything. But I don't know if it's a serious question, then yeah, of course. Is it what? The reason I'm not sure is because you said, are you wildly speculating under the guise of legal analysis? I mean, dude, this isn't legal analysis. It's a very basic procedure. Now, some business communications, corporate trade secrets, for example, can be protected. Like they could be attorney's eyes only. They could be not for public disclosure. They could be sealed by the court, stuff like that. They're still produced. They're still all turned over. You still have to do that. If it's a privileged communication, attorney-client communications, husband-wife communications in many circumstances, those types of privileged communications may not have to be produced. Sometimes they still have to be produced, but a third-party attorney will be brought in. Top secret communications, for example, if attorneys involved in a case do not have top secret clearance, but they're asking for discovery, they may have to have an attorney with top secret clearance go through and determine if these documents can be produced, who they can be produced to, if attorneys need to be granted clearance for a reason, if they need to hire, outside counsel with clearance, or if, if they're relevant at all. But you have to have, you get access to everything. I mean, discovery is exceedingly broad so long as it's related to the underlying issue. The thing is, most issues are pretty narrow. Like Russell Greer can maybe ask Josh about communications related to Russell Greer, copyright issues, DMCAs, and again, non-attorney communications. Like if Josh is talking to Scortis about this stuff, he's not entitled to that shit. Or if he's talked to other attorneys about it, he's not entitled to that shit. But communications with like random people about DMCAs or about specific copyright claims or even general copyright claims or just general thoughts on copyright, sure, he'd be entitled to pretty much anything that has the term copyright Russell or Greer in it. Probably a lot more, like Mobius syndrome, fish face. I mean, whatever you want to come up with, vagina mouth. Like you could come up with all sorts of reasons, but it always has to be pertinent and relevant to the case at hand. Discovery is not an unlimited sledgehammer, but it's a pretty fucking good limited sledgehammer. And it has to be. The idea is that you did a thing. They've given the court sufficient reason to believe that you might have done it. Now all the facts have to come out. The court has to determine if you did. All right. Whiskey Sour says, clean the 1911 tonight or wait? I think the answer is always clean the 1911 tonight. Russell Wallace Warren, welcome to Paralegal Status. Thank you. Tamara Holloway says, found out I have a 37-year-old half brother. Cheers. Well, that's cool, Tamara. Cheers to you and your newly acquired half brother. Hopefully that's like an interesting new connection that you've made in your life and you can enjoy getting to know them. Always interesting to meet someone who's related to you as an adult, but enjoy it. Dave Bennett says, X-Ray Girl said she would love to be a guest on your channel when she was on Camelot. She'll be your first Asian woman on your channel. Dude, X-Ray Girl's awesome. I'd love to have her on. I'll reach out to her. Absolutely. All right, guys. That is the YouTube portion of the show. We are going to pop over to Rumble and continue the show over there. Thanks for hanging out. If you are just a YouTube viewer, you're missing at least half of the show every night, usually more. If you are one of the people who switches over to Rumble, the link is in the description. It is in the pin chat as well. We'll either see you over there or we'll see you later tonight, or we'll see you tomorrow. Same time, 11 p.m. Central. We should have a full 5 days of streaming this week. Again, I was supposed to stream on Thursday. I didn't mention this earlier. The plan was to stream on Thursday. I mentioned this on Twitch yesterday. Let me just do this real quick. Sorry. There was a guy who called me out on Twitter, says, you won't have me on my show. And I thought he was pulling up on the Eric July situation. He wanted to have a debate on it. And again, I'm not really interested in like Eric versus Dick and Vito, but there's a whole interesting conversation around what's going on with the legal issues like desecration of a grave, for example. We've got a question here, the trademark infringement stuff, that stuff's all there. This person seemed to indicate they wanted to debate about the Eric July situation. So I said I would have them on either Wednesday or Thursday. I didn't know if I was going to do a show Wednesday. I was not able to. Thursday, I was planning to do a show. And so I said, all right, dude, send me the topics for the debate, whatever you want to talk about, and I can put them in the title, or you don't have to send them to me and we'll figure them out live. No big deal. I don't care. And then he sent back, and this guy's super nice. Again, this is not to shit on the guy. He's super nice. He said, hey man, actually, I didn't really want to debate you about the Eric July situation. I just thought it was a funny way to get your attention. And I wanted to you seem kind of stressed. I want to talk about like entertainment and anime and comics and stuff like that, and just have a really chill stream and a good conversation. I was like, oh, dude, not right now. I got a bunch of other shit to cover right now. Like, I'm happy to do that at some point down the road, but right now I'm covering a bunch of different topics and I don't want to devote a show to that at the moment. Thank you, but no. So that was not the reason I canceled Thursday's show. I was still going to do it after that, but then some other shit hit the fan in the old Rackets household, and I wasn't able to do a show Thursday night. That's about it. Nothing crazy, nothing special. It just wasn't able to happen, so didn't happen. And then, of course, I already had pre-existing plans on Friday, and I was not able to do a show then. And so then, here we are, Monday. But that's what happened with that. I know people were asking. They're like, "Whoa, did something happen with the guy?" No, nothing happened with the guy. He was super nice and very friendly, and he's been a viewer for a long time. Happy to have that conversation with him, or maybe with some other people in him. Just not Thursday night. So that's all it was. All right, guys. We'll see you over on Rumble in 25 seconds. Catch you then. Peace.